I'd ask to reserve 3 minutes, please.
All right. Whenever you're ready.
Thank you. May it please the court, as your honors are aware, this case arises from the 1993 prison riots at the Lucasville prison in southern Ohio. During those riots, 5 incarcerated people and 1 correctional officer were murdered. Mr. Cannon was subsequently convicted of the murder of one of those incarcerated people, Daryl DePina. Your honors, Mr. Cannon's conviction was wrongful, and the newly discovered evidence that's come forward in this case since the years his conviction was entered have demonstrated that the verdict is no longer worthy of confidence. As a result, your honor, we ask that this court reverse the decision of the court below and remand the case for a new trial. Your honors, this particular appeal involves the affidavit of Dwayne Buckley. Mr. Buckley was not present at Lucasville during the riots. Instead, as the court is aware, he was a jailhouse snitch. He was briefly incarcerated with Mr. Cannon at the Hamilton County Justice Center awaiting sentencing. The prosecution viewed Mr. Buckley as an important witness to their case, and we know that a couple of ways. First of all, we know that from Mr. Buckley's affidavit. Mr. Buckley in his affidavit tells us that the state went to the trouble of sending a detective out to his job site in Sharonville to collect him and bring him down for trial. Secondly, we know that he was an important witness because the state thought it important enough to call him as a rebuttal witness, and the state thought it was important enough to highlight his testimony during the state's own closing argument. Via affidavit, Mr. Buckley now entirely recants his testimony at the 1995 trial. Mr. Buckley says definitively, my testimony was not true. Derek Cannon never confessed to me. These are Mr. Buckley's statements, and they are uncontroverted in the record on the motion for new trial that was before the trial court and that's before the court now.
The trial judge didn't seem to view his new affidavit as a full recantation, right?
That's correct, Your Honor. The court's analysis was flawed in that it was in some ways too narrow, in some ways too broad. With respect to it being too narrow, Your Honor, that's correct. The trial court didn't view it as a wholesale recantation, but that's not what's actually in the words of the affidavit itself. If the court looks at paragraphs 4 and paragraph 6 of the affidavit, in paragraph 4, Your Honor, Mr. Buckley says, I knew my statement at trial wasn't true. And in paragraph 6, he says, again, my testimony wasn't true. Derek Cannon never confessed to me. Now, it is true that with respect to specifics, Mr. Buckley only mentions the murder of Officer Vallandigham, but his recantation is total in its capacity. It completely repudiates his earlier testimony, and the trial court, frankly, lost its way in limiting the impact of his testimony to just Officer Vallandigham's murder. Instead, the trial court should have viewed the affidavit as a whole, and the affidavit is sweeping. The affidavit doesn't limit itself to just Officer Vallandigham, and Mr. Buckley, in signing the affidavit, put himself at some risk of perjury because he gives himself a motive for lying. This isn't an affidavit that comes out of the blue, and we don't know why Mr. Buckley would have made up his testimony. In the earlier paragraphs of the affidavit, Your Honors, Mr. Buckley tells us why he falsified his testimony against Mr. Cannon. It started out as revenge. He got mad at Mr. Cannon because of an altercation in the Hamilton County Justice Center. So he gets mad. He makes false statements against Mr. Cannon, and then he's sort of caught between a rock and a hard place and has to come back to court because he's escorted to court by a detective and reaffirm those pretrial statements that he made. But now, 25 years later, he acknowledges that he lied. And he doesn't say he just lied about Officer Vallandigham. He says, I lied. Derek Cannon never confessed. And that's an important statement, and the trial court just missed it. But the trial court does consider towards the end of its opinion the possibility that we view this as a full-scale recantation. And that's where, Your Honors, the trial court's analysis was too broad. And it's too broad because it takes too sweeping a view of the State versus Petro analysis that says that if a statement is merely impeaching, it's not good enough for a new trial. The problem with this, Your Honor, and courts of appeals since Petro have warned against taking too broad a view of that particular factor in the Petro analysis, because anything that comes to light is impeaching of trial testimony. If newly discovered evidence doesn't impeach, that is, doesn't rebut the testimony that was offered at trial, then it's of no value at all. It would be collateral and it wouldn't make sense. Even
Mr. Castor, Mr. Castor, let me ask you a question. I know that Mr. Buckley was called as a rebuttal witness. And what do you think the purpose of him being called in rebuttal as opposed to the case in chief was?
It's hard to get inside the prosecution's head, Your Honor, and all we have obviously is the cold trial transcript, given the age of this case. But I believe that the purpose of waiting till the end with Mr. Buckley, of waiting for this final witness, was because Mr. Buckley was the only one of the state's substantive witnesses who didn't come into court in prison gear and shackles. All of the others' substantive testimony against Mr. Cannon came from people who were incarcerated in Lucasville and who are still incarcerated in Lucasville. And this court is well aware of what that testimony looks like when it comes before a jury. These individuals are not dressed out. They're in prison garb. They often come into the courtroom initially in shackles. Mr. Buckley has an additional air of credibility because he's not in shackles. He's not in prison gear. He looks like a civilian, even though his testimony arose allegedly from an incarcerated context. So for the state, Mr. Buckley's testimony is extremely powerful, and it's an excellent sort of ace in the hole for the state to hold back as a rebuttal witness.
I have a question on that, though, as far as how powerful his testimony was, because, and you can help me with the record, wasn't it revealed to the jury that Mr. Cannon was removed from the prison before that prison guard was killed?
It was.
Didn't that come to light in front of the jury?
It did. There were a couple things that came to light in front of the jury that cast some doubt on Mr. Buckley's overall veracity. That was one of the things that came to light. And also, Mr. Buckley either exaggerated or overestimated the length of time that he and Mr. Cannon were incarcerated in the Justice Center together. So
not only that, though, he said that that Mr. Cannon confessed that he shanked a white guy, and actually the prisoner who was murdered was beaten to death.
That's correct, Your Honor.
So there were a lot of things in front of that jury that already cast doubt on Mr. Buckley's testimony. So I question whether what the jury really had to do was go back to the 5 witnesses who testified for the state, who actually said they saw Mr. Cannon engage in the murder, and weigh their testimony against the witnesses that Mr. Cannon put on. Like, was Mr. Buckley really that important?
Well, and Your Honor, I think the best place to look for that, to gauge the importance, is to look at the conduct of the participants in the trial at the time. It's sort of like a Brady analysis, Your Honor. And I realize this is not a Brady claim, and I don't mean to make it one. But one of the progeny of Brady, Kyles versus Whitley, the Supreme Court told us, hey, if you want to know whether something is important enough, look at how the state presents it. Look, in fact, to the state's closing argument. And here in their closing argument, the state thought it was worthwhile to highlight Mr. Buckley's testimony for the jury. And indeed, I don't want to comment on standards of trial practice in 1995, but certainly by today's standards, the statement that the prosecutor made in support of Mr. Buckley's statements would have drawn an objection that probably would have been sustained for improper vouching of a witness. The prosecutor in the case told the jury, look, I wouldn't bring this guy in front of you if he were lying. I wouldn't bring false testimony in here. The state thought that Buckley was important enough that the prosecutor put his own credibility on the line in trying to rehabilitate Mr. Buckley's testimony. It's unfair, Your Honor, for the state at trial to take the position, oh, we got this really important witness and jurors, you should really rely on him. And then when it falls apart, as things do when people come to court and lie, to disavow that testimony and say, oh, we never really meant that anyhow. That wasn't important testimony to us. It was
what I found interesting too, though, was on the direct appeal, when this court was evaluating manifest weight, I believe they didn't even mention Mr. Buckley's testimony. So this court didn't even think it was that important. It just looked at, okay, the jury had to figure out which witnesses they believed. And while there was some credibility issues, they chose the state's witnesses.
That's correct, Your Honor. But that was a manifest weight argument, and that's a different standard than the standard here. Under Petro, the standard is, does the newly discovered evidence yield a strong possibility of a different result if that evidence were presented at trial? So here what we have is we have Mr. Buckley coming in and saying, look, I'm sorry, I lied. I gave dishonest testimony. And that, again, that's important because the state solicited dishonest testimony in this case, whether the state knew it or not.
Well, Mr. Chapter, let me ask you this. I mean, if you excised all of Mr. Buckley's testimony, how would you respond to the 4 or 5 other state witnesses that put your client in cell block L6 and had other various testimony concerning the murder? Do you understand the question? If you excised, how would the trial have been different?
I do, and I have 2 quick responses to that, Your Honor. The first is very quick, which is that the court should remember that the standard on newly discovered evidence is not to go back and do a sufficiency analysis. The question is not, once you get rid of Mr. Buckley, is the evidence sufficient to sustain a conviction? We're still dealing with, does the recantation yield a strong possibility of a different result in a new trial? The second response is, remember, we are now down to 4 witnesses. And this is where the trial court's analysis was also too narrow, in that the trial court didn't even seem to consider Mr. Cannon's argument that Mr. Buckley's recantation should be viewed alongside of Hiawatha Frizzell's recantation. We're no longer at 5 trial witnesses. Now we're at 4 trial witnesses. And with respect to the 5th who was recanted, Mr. Frizzell tells a very intriguing story, and a story that, if presented to a jury, would cast doubt on the prosecution's entire case. Because what Mr. Frizzell says via affidavit is that he was bullied by law enforcement officers into offering testimony against Mr. Cannon. In the Hiawatha Frizzell affidavit, Mr. Frizzell says, look, I was told that I was going to be charged with some of these murders if I didn't give the testimony that I was needed to give. So we don't have 5 witnesses anymore. We have 4. Res judicata, as we argued in our brief, does not bar the consideration of Mr. Frizzell's affidavit alongside of Mr. Buckley's affidavit, because it had never been considered by any court in that context before. And once you take those 2 affidavits into consideration, now we have one witness who says he had his own motive to lie. We have another witness who says he had his own motive to lie, but that motive was foisted upon him by law enforcement agents of the state of Ohio. So we have a problem, and we have a situation where the jury may well have yielded a different result if they knew that Mr. Buckley.
You are at your time if you'd like to reserve 3 minutes.
Thank you, Your Honor. We would ask for a reversal in this case.
Okay. Mr. Cumming.
Thank you, Your Honor. Your Honors, I think to reverse the trial court here, this court's going to have to find that the trial court abused its discretion. That's a very high standard. It's going to have to find that the trial court acted arbitrarily or maliciously, or not maliciously, but in finding that there was no strong probability of a different result given this new evidence. I think the standard is strong probability, not possibility. But in any case, the trial court was dead on here, Your Honors. For a variety of reasons, this court has touched upon most of the important ones. Buckley was a non-essential witness. He was a non-credible witness. Whether or not he was telling the truth at trial, or in his first recantation, or in his second recantation, really is of minimal consequence here, because he was not at Lucasville. He was not an eyewitness. He never connected Cannon to the DePina murder, either at trial or in any of his affidavits. This is a sideshow on a side issue that has nothing to do with the murder of which Cannon stands convicted of. And whether or not, somebody would believe Buckley the first, second, or third time, it makes no difference. This does not go to the core issue of the conviction.
Well, it kind of does, right? I mean, he said that Cannon confessed to him.
confessed to the killing the guard and an unnamed inmate.
Well, that's a question that I have, and that's why I asked this to Mr. Castor. I mean, was it reasonable for the trial judge to read the affidavit as only a partial recantation? I mean, he did say that he made this all up to get back at Mr. Cannon. So isn't it more reasonable to read this as a full recantation of his testimony?
I think it's reasonable either way. I think it's of note that he specifically goes on after that general statement to specify the guard confession was made up. He doesn't say the same thing, specifically mentioning the unnamed inmate. So I think there's an argument either way. Could the trial court have read it as a full recantation? Sure. Was the trial court unreasonable in not doing so? Not necessarily. I think, though, the issue still becomes, was the trial court abusing its discretion in not granting a new trial here? And I think the answer is clearly no. New trials are to be reserved for compelling cases, very extraordinary cases. Perhaps a case where, if Buckley had said, hey, Cannon confessed to me that he killed DePina, and then that was recanted, maybe we have something to talk about. But that's not what happened here. This guy was not an essential witness. He was not called by the state in its case in chief because he could not connect Cannon to DePina.
But I'm trying to understand, though. I mean, I thought, granted, he didn't name DePina in his trial testimony, but the reason why the state put him on as a rebuttal witness was because he was going to testify, or did testify, that Cannon confessed to him the murder of which he was on trial for, right?
Well, I don't know what he told the prosecutor before he took the stand. I know what he said at trial, and he never mentioned DePina. He just talked about the guard and an unnamed inmate.
Well,
so that's
clearly that's why the prosecution put him on. Was to say that he confessed.
Possibly the prosecutor knew exactly what he was going to say, and he said exactly what he told the prosecutor he was going to say. And this was a case of giving the jury the setting of the case. I think a lot of the defense witnesses at trial had said that Cannon didn't return to the block and wasn't involved in any murder, not of the snitch inmates or of the guard. So I think to the extent that Buckley could have, shed credibility issues on the defense witnesses, that might have been why he was called in that sense. He kind of gave the context to that, called the defense witnesses into question. But at the end of the day, as to the substantive issue of what everybody was there to determine, the murderer of DePina, Buckley couldn't speak to that, and he never has spoken to that. Any things that he says, it's just by implication and speculation that maybe he meant DePina, maybe he didn't, maybe Cannon referenced DePina, maybe he didn't. This is not the kind of case where you grant a new trial in such weak new evidence. This is just not it. The trial court.
How do you respond to Mr. Castor's argument that the state really relied on Buckley in its closing argument, which demonstrates just how important he was to their case?
That's just good advocacy. I mean, in a closing argument, you present your best case. You put forth the strongest case you can, and you make the best argument you can. And you characterize all evidence as important, and it's all for the trier of fact to consider. But as you noted, Judge Krause, Mr. Buckley's credibility was already called into question in front of the jury before this case was even given to the jury. He was already shown to have been mistaken about the timing and the chronology of the murder of the guard. So Mr. Buckley had credibility issues going into the deliberations, and he continues to have credibility issues to this day, regardless of what recantation you choose to believe. If there's a new trial here, it's not going to be a different outcome, Your Honors, and I don't think Mr. Cannon has demonstrated that standard. There's not a strong probability here. And you.
Well, what about the argument of Mr. Frizzle, who also did an affidavit recanting his testimony? So now you have at least one other witness that out of 5 that allegedly saw the murder, said they saw the murder, recanting, plus the rebuttal witness.
Well, I think since Mr. Frizzle wasn't there, it's kind of hard to comment. I know a prior judge looked at that and said specifically that Frizzle was not credible, and he denied a new trial at that time on that basis. I think in light of the lack of a record on him in this hearing, I think this court has to fall back on standard precedent, which is recantation of previous trial testimony is always to be regarded with the utmost suspicion. So it's going to be hard to hang a hat on Frizzle's recantation when he's already been found to be incredible. There was actually evidence at that hearing back in the day that he made that up because somebody explained that he had explained his recantation to an investigator. But in any case, that is so far removed from really what was explored below. It's kind of hard to substantively comment on that. The cumulative effect would have been zero, Your Honor. I have nothing to add, Your Honors, unless this court has any specific questions. I think the trial court got it completely right here.
Okay, thank you. Mr. Castor, rebuttal?
Thank you, Your Honors. This case represents a quarter century of injustice, and this court has the opportunity to fix that in this decision. With respect to the standard review, of course, I agree with learned counsel that the standard is abuse of discretion, but this court should remember, under the narrow circumstances of this case, the way in which it arises. This court really is reviewing the court below in the same way, for the most part, that it would review a summary judgment decision. The trial court in this case is not in any better decision than this court is to review the evidence for two reasons. First of all, it wasn't the original trial judge sitting on this motion who sat in the 1995 trial. And secondly, Your Honor, this case was decided because of Mr. Buckley's subsequent invocation of the Fifth Amendment on paper affidavits. So the credibility issues that are usually at play in an abuse of discretion decision aren't as fraught in this case. But secondly, Your Honors, with respect to whether or not Mr. Buckley was an essential witness, opposing counsel says, well, hey, pointing out Mr. Buckley in closing argument is just good advocacy. Well, I would submit, first of all, that trial counsel for the state in this case is and was a very good advocate. But secondly, that the notion that you highlight the testimony of a weak link in your case in closing argument belies everything I've ever learned about good trial advocacy. You don't highlight the weak points of your case. The state didn't view Mr. Buckley as a weak link. They viewed him as important. The state engaged in conduct that makes Mr. Buckley's importance clear. They sent a detective out to get him. They brought him down to testimony, and then they made sure in their closing arguments that the jury remembered what he had to say. And as the court was pointing out during its questioning, they didn't call Mr. Buckley to testify about the murder of the correctional officer because that wasn't what Mr. Cannon was charged with. The state thought that Mr. Buckley helped the state make its case with respect to the murder of Daryl DePina, and that's why they put him on the stand. The state cannot distance itself now from its decision to treat Dwayne Buckley as an important witness, from its decision to hold Mr. Buckley until the end and put him on as a rebuttal witness. Your Honor, this court is well aware of the statistics around wrongful convictions. They're very well publicized. With respect to eyewitness identifications, those are the number one cause of wrongful conviction. False confessions are number two. And in this case, we have not a false confession, but a confession that was lied about. But we know that false confessions, any type of confession that a jury hears or reported, we know that the jury puts huge weight on confessions. This alleged confession, Your Honors, never happened. It happened because Mr. Buckley got ticked off because of an altercation with Mr. Cannon in the Justice Center. It happened because once he told someone about his lie, he had to double down on his lie once law enforcement escorted him to trial.
Thank you, Mr. Castor. You are
Your Honor.
time. Thank you. Thank you both for your arguments. We will take this case under submission and issue a timely decision.
Thank you.
Thank you.
And this concludes our session today.